Hello and welcome to A Lawyer Talks. I'm Joshua Rosenberg, and this week I'm talking to a man who defeated the Ministry of Justice in the Court of Appeal, which means his name is now in the law reports.
Yes, I know that. That's just a bonus. It hasn't properly sunk in yet, but obviously that my name is going down as precedent, and it's in the history books now, which is crazy.
More from him later. This is the third in a series of on-air pilots for A Lawyer Talks, ahead of the weekly podcast I plan to launch in September. I've decided to begin this episode with a roundup of what's going on in the law. On Friday, the new Justice Secretary, Shabana Mahmood, announced plans to release some prisoners serving fixed sentences after they've served 40% of their sentences in custody rather than 50% at the moment. That won't have come as a surprise to anyone who's been reading my Substack blog, A Lawyer Writes, over the past couple of months. But what we haven't seen so far are the detailed regulations that Mahmood will sign. I had the impression that this measure would apply only to sentences of 4 years or less, but she didn't quite say that. The only exclusions we know about are sentences for serious violent offences of 4 years or more, as well as sex offences and those involving domestic abuse. Incidentally, I noticed that in her first speech as a cabinet minister, Shabana Mahmood introduced herself as Lord Chancellor and Secretary of State for Justice. The press notice announcing her prison reforms referred to her throughout as Lord Chancellor, an office with more than 900 years of history behind it. By contrast, the Ministry of Justice was created less than 20 years ago. I'm pleased to see our new Lord Chancellor's respect for ancient traditions, and I look forward to seeing more of it this week when the Lord Chancellor is sworn in by the Lady Chief Justice, the first time the two most senior legal posts in England and Wales have been held by women. By the way, I strongly suspect that Baroness Carr of Walton-on-the-Hill will be keeping a close eye on the prison sentences that a judge will pass this Thursday on 5 environmental campaigners who were convicted last week of conspiring to cause a public nuisance on the M25 motorway nearly 2 years ago. Activists climbed onto gantries and the police were required to stop traffic. There seems to be every chance that the Lady Chief Justice will hear the defendants' inevitable appeals, presumably against both conviction and sentence. So there's a lot going on. Last week on A Lawyer Writes, I looked at the British judge who was prevented from holding a hearing in a British overseas territory by officials working for the United States government. I wrote about a minister in the last government who's been warned that he faces prison if he doesn't provide information requested by a public inquiry. The Law Commission is proposing changes to contempt of court, and the Law Society is deeply concerned by its regulators' willingness to regulate legal executives. This week, the government will set out its plans for legislation in the new Parliament, and the shocking assassination attempt on Donald Trump at the weekend is bound to focus attention on the vulnerability of politicians in the United Kingdom. If there's something that keeps me awake at night, the newly elected Speaker of the House of Commons told the BBC last week, it's the safety of MPs. Whatever happens, though, the courts will do their best to deliver justice, even if justice, or the department responsible for it, is in the dock. And that brings us back to the man we heard from at the start of this podcast. His name is Michael Burton, he's 49, and he lives near Hull. Nearly 4.5 years ago, in February 2020, he was fined for speeding by magistrates in Harrogate. With the victim's surcharge and costs, the total amount payable was just over £300. He'd paid most of it by the end of 2020, despite being made redundant from his previous job, but £83 was still outstanding. Now, if you don't pay a fine, the magistrates can issue what's called a warrant of control. That creates a debt payable to the Ministry of Justice. The debts are collected by private contractors called approved enforcement agencies. The best known of these is a company called Marston Holdings. They charge the debtor a recovery fee, so there's no cost to the court service. Marston Holdings use self-employed enforcement agents, or bailiffs as they used to be called. In January 2021, one of these enforcement agents turned up at Michael Burton's home. Craig Edward Allen produced a demand for £83, plus fees of £210. Well, Mr. Burton didn't have £293 on him, but there was a car in his driveway, and Mr. Allen was photographed fixing a clamp to one of its wheels. "You can't do that," said Mr. Burton. "The car doesn't belong to me. It belongs to a finance company. Look, here's the hire purchase agreement. It doesn't become mine until I've paid 5 years of instalments." He even took a picture of himself showing the agreement to Mr. Allen, which you can see on my website. None of this should have come as a surprise to the debt collection company or its enforcement agent, Michael Burton told me.
Because I'd sent all this information previous to Marston's, and then we got into arguing about points of law, and obviously the enforcement agent was not interested, and I was explaining to him that he couldn't clamp my car because I didn't own it. It was owned by the hire purchase company, and he just said, "Oh, I can do what I want. I work for the government," type thing. I'd been advised, so just show him my HP agreement, show him all my details, and he still just totally ignored me and went ahead and did it anyway.
Michael Burton's solicitor is Sarah Hughey. She says it's rare to find clients who know their rights.
Mike was so well prepared. I mean, most clients have no idea of the law, but Mike had done his research. To be able to actually show a photo of the enforcement agent looking at the hire purchase agreement is remarkable. You don't get better evidence than that.
He just wasn't interested in no matter what I said or what I did. He was just like, "Well, I'll do what I want."
And he did.
And he did, yes.
Sarah Hughey issued a civil claim against the Ministry of Justice at the Kingston-upon-Hull County Court. 6 days later, a district judge ordered the clamp to be removed. Because Mr. Burton had been wrongfully deprived of his car, the judge awarded him nearly £900 in damages, plus £35 for each further day the vehicle remained clamped. But nothing happened for a fortnight, he says.
The clamp was left on the car for 2 weeks, even though we got an injunction, and the first judge agreed with the point of law that I brought up with the help of Sarah and said, "Yeah, take the clamp off. You've got no right. You broke the law. You had no right to clamp it. Go and take it off." But again, it was still 2 weeks before they came back and took it off.
So everything would have been resolved. We got a very quick hearing, which is remarkable. And I served everything on the government legal department as per their instructions. But they applied to have the order set aside on the basis that their procedures weren't set up to be compliant with the CPR.
CPR stands for?
Civil Procedure Rules. They couldn't act as quickly as is required for the CPR.
But we're talking about the Ministry of Justice, aren't we?
Correct.
They make the rules.
And I don't think such an indulgence would have been granted to anyone else. If you got any business or any ordinary individual that wanted to set it aside and they'd been served properly, they would have been told, hard luck, you were served. You didn't get your act together in time.
In any event, there was a full hearing in October 2021 before a deputy district judge. She agreed that the car shouldn't have been clamped. But then Mr. Burton ran into difficulties. The Ministry of Justice argued that it wasn't required to pay him any compensation at all, and the judge found that the enforcement agent had a defence. He had a reasonable belief that the car belonged to Mr. Burton. But he can't have had a reasonable belief that he was complying with the law when you told him that the car was on hire purchase.
Exactly. And I informed him of that and gave him the statute. I printed out the legislation and informed him of it. But he said, "Oh, no, I work under a different legislation." Not only that, he said he had a warrant of control or whatever it was. I said, "Well, can you show me it?" And he didn't have any paperwork with him. He said he's got something on his iPad. It was just like, well, I don't believe it. I said, anybody could walk up to my door and say they've got a warrant of control. Show me it if you've got it. And then they didn't even produce the warrant of control as evidence in the court.
It wasn't a warrant of control, and they've never been able to produce us a compliant warrant of control. They certainly never had a printed out warrant of control that should have been endorsed by the enforcement agent doing the enforcement.
Michael Burton was given permission to appeal. This time the case was heard by a circuit judge. She agreed that Mr. Allen couldn't reasonably have believed that the car belonged to Mr. Burton, but there was a different problem. In her view, Mr. Allen was not an agent of the government. Instead, he was an officer of the court. If he wasn't working for the Ministry of Justice, then the government didn't have to pay Mr. Burton damages. Is that right? Surely the enforcement agent was working on behalf of the creditor, in this case the Ministry of Justice. Well, fortunately there's guidance on this, national standards for private sector enforcement agents who are recovering debts owed to the public sector. The guidance says,
creditors should remember that enforcement agents are acting on their behalf and that ultimately they are responsible and accountable for the enforcement agents acting on their behalf.
So creditors, and that includes the court service, which is part of the Ministry of Justice, these creditors are responsible and accountable for enforcement agents like Mr. Allen. And who published this guidance? Well, it was none other than the Ministry of Justice itself. Sarah Hughey was amazed.
The remarkable thing I want to tell you about this case is that the Ministry of Justice produced a guide to enforcement which sets out that creditors are responsible for the actions of their enforcement agents. And throughout the hearings, they said that, in fact, basically that's rubbish. So they said, we produced this guide, but the guide is not actually the law.
The Court of Appeal was unimpressed with the Ministry of Justice's attempt to argue that its own guidance was wrong. Parliament had said in terms that the court may order a creditor to pay damages for losses suffered by a debtor as a result of a breach by an enforcement agent. And there were public policy arguments for keeping a close eye on these enforcement agents. Debtors are often in a vulnerable position, said Lord Justice Phillips, and enforcement agents, who have powers to interfere with the human rights of the debtor, including power to force entry to premises, have private financial incentives such that they should be monitored and supervised. It's the creditor, and the creditor alone, who's in a position to supervise the enforcement agent, either directly or through its delegate. All three appeal judges were persuaded by Daniel Kessler, representing Mr. Burton, that the courts could order the Ministry of Justice to pay damages, and that included his taxi fares. So, by fighting the case, the Ministry of Justice has ended up with the opposite of what it was trying to achieve. The case of Michael Burton against the Ministry of Justice, decided by the Court of Appeal on the 21st of June, is important. There are nearly 500,000 writs of control and warrants of control issued every year, but this is only the third case to reach the Court of Appeal in a decade. I suppose that's not really surprising, though.
There are very, very few solicitors that do enforcement work, actions against bailiffs. The legislation is difficult because it's fractured. There's a number of different acts and there's not a lot of established case law, and it's poorly drafted. So it's made it a nightmare for solicitors to deal with. And to be frank, a lot of the debt that bailiffs chase is low value debt. There's not much money in this area of practice. And debtors also are impecunious to a large extent. So it's difficult to make money in this area of practice. So I'm one of the few because I see law as a vocation.
There's lots of malpractice in the enforcement industry as it is, and they know that there isn't many people like myself who would know their rights and who will stand up and enforce those rights against them. They just ride roughshod, and a lot of bailiffs and enforcement officers just do what they want, and they think they're above the law. So this case is a case to say that nobody is above the law, not even the Ministry of Justice.
You see, you've got to understand, you've got a very significant imbalance whenever debtors go to court. Debtors often have never been in a courtroom before. Certainly never more than, let's say, before a magistrate for a parking ticket.
And generally, judges, they look down upon debtors, and they really don't have a good view of debtors. They always take the creditor's side without using the law as such. And there's laws been written to protect you, and a debt is a chosen action.
A chose in action, in case you were wondering, is a right to bring a claim, in this case to recover a debt. It's not a phrase you hear very often these days, even from qualified lawyers. What was it then that persuaded Michael Burton to fight this case all the way to the Court of Appeal?
It was not the money, it was principle, because I knew I was right, and I knew Sarah was right, and we knew it was a point of law. So therefore, I had to teach myself and find out, why are we in this situation? How do you get out of this situation? Well, it's my interest in the law and trying to increase my education and knowledge and create a better situation for myself to try and get out of this whole and robbing Peter to pay Paul situation, which is what generally most of the population are stuck in. We're running in tar and we live in a credit-fueled environment, so you have to teach yourself law to try and protect yourself.
In the end, because you won in the Court of Appeal, you don't have to pay any of the government's costs. On the contrary, they presumably have to pay some of your legal bills.
That's correct.
Sarah, it's quite a risk for you as a solicitor.
As I say, it's a vocation. It's always been a vocation for me. I became a solicitor in order to help ordinary people. I started out in a very big city firm at Linklaters, but that wasn't the law that I'd always seen myself as practicing. And I couldn't wait to get out and just help ordinary people with ordinary matters that absolutely affect their life. And oftentimes the matters I deal with for people look as being low value to the rest of the world, but are life-changing for my clients. Or else they prevent them having life-changing events, such as loss of their home, loss of their livelihood. And with enforcement issues, it's oftentimes when they lose their car, if they live in a rural environment where there's not many buses, they lose their jobs. They then can't pay their mortgage. They lose their home. So the work I've been doing for countless others, not just Mike, is really important in my view. But it's very, very poorly paid. I wouldn't advise many solicitors to do this work if they need to finance their family.
And you must be so relieved that it's come right in the end.
Well, I am relieved because just like Mike, I share the burden of not wanting to have a High Court precedent that for decades to come would disadvantage debtors.
The main takeaway I get from this is that this is the win for debtors and people with limited financial resources who often don't have access to justice. It's widening access to justice.
Your name will be attached to this judgment, and when it's cited, when it's quoted in future cases, it'll be your victory that will be decisive for other people in your position.
Yes, I know that. That's just a bonus. It hasn't properly sunk in yet, but obviously that my name is going down as precedent, and it's in the history books now, which is crazy.
Well, you must be very pleased.
I am. And thank you, Sarah, and Daniel as well. They did a fantastic job. They didn't pressure me to carry on. We all knew what was right, and we all pressed forward.
Michael Burton thanking his lawyers. But that's not quite the end of the story. The Civil Justice Council was set up to advise the Ministry of Justice and the judiciary on civil justice issues. At the beginning of this year, it set up a working group on enforcement. Last week, the working group published a call for evidence. I think this is more about enforcing civil judgments and fines, but I hope that the case of Burton against the Ministry of Justice will receive an honourable mention. That's the end of this edition of A Lawyer Talks, presented by me, Joshua Rosenberg. Sorry for some of the rough edges, including my voice. As I say, this is just an on-air pilot, a proof of concept, if you like. Do let me know what you think of it by leaving a comment on my Substack blog, A Lawyer Writes. And sign up to make sure you don't miss another word.